Thank you everybody for joining our Contentious clinic today. We have been off for August, so we are about with a bang for September, and we seem to have filled the room today almost. Today we have Stephen Lawson, one of our partners, presenting for us on the appointment of and removal of executors, as you can see there on the screen. Over the next few months, we have got Eleanor Stenson, another one of our partners, joining the clinic in October, and our new associate, Kate Lister, will be presented in November. So without further ado, I'm going to hand over to Stephen. If you do have any questions throughout the session, if you can add them to the chat, then I'm sure Stephen wouldn't mind answering those at the end. Or you can always email him if there's anything that you want to ask but don't want to put it into the chat. I'll add any emails into the chat as we go forward. Just a reminder, you all probably heard about this via our IDRN or LinkedIn page. So please do, if you haven't registered for the IDRN, please do register, because the recording of the session and any upcoming sessions will be added to that. So you can share with your team or rewatch yourselves if you miss anything. So anyway, I'll hand over to Stephen and I'll just continue letting people in. Thank you.
Thank you very much, Lindsay. Firstly, a thank you for being here. And it's not a surprise really to me that you've all wanted to join, because disputes about appointments of and removal of executors seem to have gone through the roof for us. You know, when I started, it was only once in a blue moon you'd get a dispute about removal of executors, but now it's a major part of our business. And there's all sorts of reasons for that, because often there's a dispute where, for example, one of the beneficiaries won't get out of a house, and that then puts the executors in a difficult position. How do they proceed? How do they make progress? Sometimes testators themselves contribute to the dispute. Honestly, we've come across one letter in a financial advisor's file which said, I really don't care what the executors do when I'm not here, because I won't be here, and they can fight about everything themselves. And it's quite a common theme. A lot of people, a lot of testators just don't seem to care about what happens once they've gone. Disputes between executors fall into a variety of categories. So sometimes there's executors between, if there's two or more executors and they can't agree. I mean, we had a dispute where there was a house that got damaged before it was sold, and the executors just couldn't or wouldn't agree about how to do repairs, and the whole thing came to a standstill. Sometimes there's a dispute between the executors and the beneficiaries, and it's almost like there's a war between the two sides, and they see each other rather as a collaborative approach, as a dispute, as I say, as a war between two sides. Sometimes there's a dispute where a solicitor or a firm's appointed as executors, and the beneficiaries disagree, perhaps from the outset. Now, my colleague, Martin Holsworth, calls these Boyd files. He calls it bring out your dead. So if there's a dispute, that's one of the times when people come to us, because sometimes lawyers dealing with the administration of an estate, either as executors or if they're just acting for the executors, sometimes it's really difficult. I wonder why anybody would want to be an executor, really, because the pressures that get put on executors can be huge, with one effectively one camp saying we want you to do this, and another camp saying we don't want you to do that. And it's really difficult for an executor, and sometimes executors just freeze and don't really know what to do, and they think the easiest thing to do nothing. But then that often leads to an application to remove. So, as I say, one of the things that firms often do with us is share those files and just talk it through with us, and we can often find solutions. I started with his preliminary comment from a barrister at St. John's Chambers, who originally said, generally, save in cases of actual wrongdoing or fraud, courts are very reluctant to remove personal representatives, but then goes on to say the court's got a broad discretion, and the result of applications will be difficult to predict with any certainty. So I'm going to come back, hold that in your mind, because we'll be looking at costs towards the end, because costs, to me, is a major factor which sometimes isn't properly considered. The Chief Chancery Master is a bloke, he's now retired, called Chief Master Marsh. As I say, he's retired, but still sits as a deputy. And he gave a talk for ACTAPS a good few years ago. And he said, picture this. You're a solicitor and the administrator of an estate. Your firm has acted for a family which has been and still is an important source of business for your firm. You knew the testator, you're appointed as a professional executor alongside two members of the family to hold the ring between them. You have in your mind faithfully performed your role over several years, and the beneficiaries now say, and the other executors, you and your firm have not met the standard they expect. You feel hurt and aggrieved. You feel you should refute the allegations. You're a professional person and you want to clear your name. Now, that is an entirely understandable approach or response to executors who are going about. We all do a difficult job day in, day out, and by and large, we all do the best we can for our clients, and sometimes they don't appreciate what they say. But I've got a theory, okay, and it's sort of borne out by some of the evidence that I'm going to give to you. And the theory is that solicitors and others are sometimes getting themselves appointed as executors when they should not be appointed as executors, where you've got a simple estate, for example. But the opposite also applies. There are times when solicitors should really be appointed as executors and shouldn't be afraid to put themselves forward as executors, because solicitors and will preparers can be in a unique position to hold the ring between aggrieved beneficiaries, where some beneficiaries think, I want more of the estate, and some beneficiaries think, I want them to have less of the estate, or some beneficiaries will want to say, oh, I want to carry on living in this house. It's nice and comfortable for me to do so, and I don't want the executors to sell it. Now, those are precisely the sorts of cases where a strong independent administrator can really help the estate of a testator, and in the long run help beneficiaries as a whole. And solicitors are sometimes afraid to put themselves forward. If we deal with applications to remove executors, I like to start at the very beginning, the appointment of executors. And so we often look and ask for production of a copy of a will preparation file. So if, for example, a solicitor's got themselves appointed as an executor, we'll want to see what advice they gave to the client. And this was one that came up recently. This was in a firm standard client care letter that said, if you've not already done so, I would strongly recommend that you include a professional executor as one of the executors of your will. This will ensure that somebody who's independent and an expert in the field, i.e. someone who does not benefit from the will, is able to advise your family and the other executors about the procedure for dealing with your estate once you have passed away. And as a firm, we are able to provide this service to you. Well, that's not quite right, is it? Because solicitors can act as executors when they're can be appointed by the executors to give independent advice and allow the executors to deal with the decisions that need to be made. And this advice is reflected by the Law Society. I'm forever saying to people, go and look at the Law Society practice notes, because they're an invaluable source of free legal advice. And what they say is that if you decide to promote your services, you should also take into account the client's best interests. You should therefore consider the constitution and complexity of the estate, as well as those who are to benefit absolutely or under the terms of a trust before, and that's my emphasis, promoting the services of a professional executor instead of a lay executor. Now, that precisely encapsulates what I've been saying to you, because if you've got a low value, simple, straightforward estate, one might question whether a solicitor needs to be appointed as an executor rather than the beneficiaries. And we'll see later on in this talk some of the cases where it's gone wrong in those circumstances. But the converse is true. If there is a complex estate and beneficiaries who it might be foreseeable are going to fall out between themselves, that's a very good reason for getting solicitors are appointed. So the Law Society Practice Note says this: if the estate's small or straightforward, it might not be appropriate. Conversely, the appointment of a less robust lay executor might be problematic where there's an overbearing beneficiary. And this goes back to me to file notes, what solicitors write in a file note or what they get their clients to write to them. If your client's written you a note that says, I'm asking you to be an executor because my estate, I recognize that my estate's potentially complex and members of my family haven't always got on together, and therefore I'm asking you to act as an executor. That can be a very powerful weapon for an executor to be able to respond allegations later on that they shouldn't be appointed. And far too rarely we see that sort of information in a file. People just don't tend to write it down. They just think, oh, right, I'll act as an executor and that's it, without, if you like, letting the voice of the testator speak from beyond the grave. But the Law Society go on, and there's a reason why I'm telling you all of this start at the beginning, because the Law Society say you should provide an indication of the likely current costs of both carrying out the administration of the estate and as acting as an executor. You should inform the client whether the fees quoted are based on an hourly rate and or as a percentage of an estate. Now, as I say, if we want to challenge the appointment of an executor, and it's a solicitor, for example, we ask for the solicitor's file, and if the solicitor hasn't given this information and can't prove it because they can't produce a letter, the solicitor is starting, if you like, almost on the back foot, because we can start saying very, very easily, well, you've not complied with the best recommendations from the Law Society, and our clients don't want you to act, to be blunt. That's the way we would do it. And as a sharing insight, we just dealt with a case like this where the solicitors got themselves appointed, hadn't given the testator any cost information, and then said, after the testator died, oh, by the way, we're going to charge 1.5% of the capital value of the estate, which was a £22,000 windfall for the executors, for the solicitor. And that doesn't go down too well. And if you're not careful, besides facing an application for removal, you can very easily get involved in professional complaints before the legal ombudsman or the SRA. And that's something, our lives are complicated enough without having to deal with additional issues. So if you're going to get yourself appointed as an executor in the first place, make sure you comply with Law Society recommendations and make sure you give objective client-specific advice. Don't say to all your clients, oh, by the way, you should appoint us as executors. So it's sort of a strange place to start, but if we're asked to look at removal, we always look at, why has somebody been appointed in the first place? Or is it just a statement in a will? So we look at the removal of executors now. Now, most firms, it's easy to say, are not members of the Law Society Wills and Inheritance Quality Scheme. I think there's about 8,000 firms of solicitors in England and Wales. Only about 180 are registered with the Wills and Inheritance Quality Scheme. It's a firm-wide quality scheme rather than you can't get accreditation as an individual, all right? But I'm always recommending to people, look at the WIC scheme. It's free to download. You just type it into Google, Law Society Wills and Inheritance Quality Scheme, and there's a protocol there. And the reason that I talk about it as passionately as I do is because it was written by some of the leading, it's a few years old now, it was done in 2013, but it was written by leading practitioners, including Professor Leslie King, Patricia Wass, a former predecessor of mine as chair of the Law Society Wills and Equity Committee, that was Richard Roberts. And the whole scheme deals with the best steps, if you like, that solicitors should take, both in connection with will preparation, but also in relation to administration of estates. And I'm forever saying to people, look at it because it's got good information about Inheritance Act claims. It's got good information about testamentary capacity, the steps that solicitors should be taking. So it represents best practice. But the WICS scheme says a practice will have a written policy which sets out the way it deals with requests for enunciation. Now, a little bit naughtily, perhaps you will think, if I'm asking for and we deal with it both ways. Don't get me wrong. We defend practices, we defend executors, but equally we pursue claims to get people removed. And our practice is probably split equally between the two. But if we're seeking the removal, we ask people, oh, can we have a copy of your written policy setting out the way it will deal with your requests for enunciation? And of course, if firms say, oh, we don't have one, again, that's the third you're on the back foot. You know, if you've not given your cost information and you've not given the other information, you haven't got a written practice, a written policy, you start to feel, oh, you know, it's you're on the back foot. So some firms I know, if they think there's going to be trouble, will remove themselves by consent. In the old days, you had to do a deed, but of course now there's the relatively straightforward PA15 form that you have to fill in. Now, the problem with that form, if you like, is that it's supported by a statement of truth, and you have to declare that you haven't intermeddled in the estate. So if you've held yourself out as an executor, even if you want to renounce, you can't renounce by consent, and you've got to get a court order to do that. Now, it's administratively complicated. The fee is over £600, the court fee, but it can be done by consent. So it's not the end of the world if you have intermeddled, but you need to protect yourself if you're consenting to make sure that somebody will pay your costs for getting a court order by consent. Now, there isn't any sort of inherent jurisdiction to remove yourself. The court has powers under, this is my legal bit, and then we'll get back to practice, but the Administration of Justice Act, the power of the High Court, and it's only the High Court, to appoint, substitute, or remove a personal representative. Where an application is made by a personal representative, so they can apply themselves, or a beneficiary, the court may, in its discretion. Now, that's an important word to you to see there. It's a discretionary power. A lot of people, as we sort of said at the beginning, think, oh, if I'm being removed, that implies misconduct of some sort. It doesn't imply any misconduct. It's a discretionary power. So this says that the court has power, as I say, to appoint a new PR. If the two or more existing PRs, then of course the court can't get rid of everybody unless there's another PR appointed. The other power is under Section 116 of the Senior Courts Act, where if there's reason by special circumstances to appoint somebody else, then the court can appoint such other person as it thinks appropriate. The jurisdiction under the two powers is broadly the same, but under Section 116, the court has power to pass over a person who has a prior claim to a grant. So it can appoint, say, a residuary beneficiary rather than just an executor. It's more limited circumstances, and 116 can't be used after a grant of probate has already been issued. But you can use either power, is what we say. Most people use Section 50, just refer to it, because if you have to start court proceedings, you have to refer to the jurisdiction, and it tends to be Section 50. So I've told you that courts got a discretion, and again, it falls to courts to look at the discretion. If you say, no, I don't want to be removed, what is likely to be outcome? Well, again, Chief Master Marsh, very experienced judge, and he gave guidance in this case. You'll forever remember it. It's such a strange name, isn't it? Harrison Earwicker, back in 2015. And he set out the principles, the issues to be considered. And this reflects what I've already said. The court doesn't need to find wrongdoing. So again, I'll say again, a lot of executors think, how dare you seek to remove me? I've done nothing wrong. That's a common sort of response we get. It's not necessary. You can still be removed even whether there has not been wrongdoing. The guiding principle is whether the administration of the estate is being carried out properly. Put another way, looking at the welfare of the beneficiaries, is it in their best interest to replace one or more of the PRs? And if you're faced with beneficiaries saying it's in our best interest for you to be removed, it can be difficult to object to that. If there is wrongdoing and it's likely to endanger the estate, the court is likely to exercise its powers. We dealt with a solicitor who had been an executor, but she'd been suspended by the SRA. Well, it was fairly obvious that the court was going to remove her as administrator, and indeed the court did remove her as administrator and ordered her to pay the cost. If there is some proper criticism, but it's minor and doesn't affect the estate, it might well not be necessary to exercise the power. So there's a balance there. The wishes of the testator as reflected in the will concerning the PR is a factor to take into account. I'll tell you about a case a little bit later on in this talk where you'll see just saying, look, I'm the executor, I'm named as such in the will, doesn't actually carry a lot of weight. And simply reflecting that in the will doesn't carry much weight, as I've said. What is much more powerful is the solicitor's file note, or ideally something from the client. Get your client to write you a note, look, you've been my solicitor for the last 40 years. I trust you implicitly. I'd like you to act as an administrator in this case or something. And then if you can add more, look, I'm worried about the estate complexity and there might be disputes between the beneficiaries, it all adds to the weight for you being appointed. So don't regret or don't neglect to get a note on your file if you can. The wishes, this is what Master Marsh said, the wishes of the beneficiaries are relevant, but they don't have a right to demand replacement, and the court has to make a balanced judgment taking into account the interests of the beneficiaries as a whole. Now, again, all circumstances are different. Sometimes, a court will say, a testator will say, I'll leave all my estate to my two children. Well, if you've got the two children both saying we want you to be removed, that can cause you a problem. But if there's lots of beneficiaries and perhaps some charity beneficiaries in there as well, and some beneficiaries say we want you removed and others don't, that can cause the problems. Again, we'll see that a bit later. The court needs to consider whether in the absence of significant wrongdoing, it's impossible or difficult for the PR to complete the administration of the estate. And it emphasizes just a breakdown of the relationship will not without more justify replacement. But if the PRs can't do their job, then replacement might be the only option, even if the executor's done nothing wrong. And this is relevant as well. The additional cost of replacing the PRs is going to be relevant. So if it's at a very, very early stage, perhaps before a grant has been issued, then there's not going to be much additional cost. However, if there's been a huge file, a really complicated administration, and all you've got left virtually is distribution, it might as well just be easier just to get the distributions made rather than removing the executors. But look, we'll see a case below in a minute. The early correspondence passing between the parties, it's really, really significant. So if you get a request, we want you or your client to be removed. If you go back with hostile response, as some people can do, they can be very hostile in their correspondence, it's not going to get a lot of sympathy from the court. A court would want you to be seen to be considering a request for your removal very carefully and very sympathetically, because that, at the end of the day, we've just said there are fundamental core duties under the SRA code of conduct. We've got to do what's in the best interests of our clients, and to a degree, beneficiaries come within that scope. So we want to look after our clients and enhance our reputation. I would say there's been some solicitors that I've dealt with who've made a very early and very generous request to step down. And really, that just enhances their own reputation. You know, you've got lawyers, rather than fighting you, we'll see you in court. Go, yeah, of course, just pay us for our costs incurred to date, and we'll go away. After all, why would you want to carry on with the estate if everybody was against it? So I'm urging you really to look at a request, maybe get more information from a claimant who's saying we want you to stand down, and get them to flesh out the bones, because it might not be what's in the best interests of the estate, but consider it sympathetically. Court procedure: if people don't step down, ultimately you start court proceedings. It's relatively easy for a lawyer to start court proceedings, or indeed a litigant in person. It's what you call Part 8 proceedings. So that's a claim form and a witness statement saying why somebody wants you to step down. There's information that the rules of court say that you've got to give to the court, like the people with an interest in the estate, the size and value of the estate. And that's because if you haven't involved all of the beneficiaries, the court might want them to be added as a defendant in the proceedings, or at least give them the option to be involved in the court proceedings. Now, this is the other thing, right? This is the big difference with what you call Part 8 proceedings. There isn't usually a trial with oral evidence. So you don't usually, on one of these applications, turn up and the person who's wanting you to step down, or the executive, doesn't give evidence and say they did this, they did that, they've made mistakes, they've done everything, and then the executor doesn't get in a witness box to say, I refute it, it's not true. A court doesn't make findings, doesn't usually make findings. All it looks at is whether there are reasonable grounds for somebody to be removed. The alternative powers are under the probate registry, the non-contentious probate rules, where if before a grant somebody needs to step down, for example, by mental incapacity, then the court can, the probate registry can remove somebody by a summons, which avoids court proceedings, avoids court fees, and all of the rest of it. So if things are agreed right at the outset, but you've intermeddled, or somebody can't consent to be removed, as I say, like from lack of capacity, then it can be done by consent. Now, I draw your attention to this case, right? Because I'm going to look at a few cases. I don't know whether you know, and I'm happy to put my name to it. Higgs & Co. are an eminently reputable firm of solicitors in the West Midlands. And Lucy Aubrey is a very well-known lecturer. She is in the middle of the photograph there. And it just shows you, sadly, how things can go wrong, even for the best of solicitors. Because this was a case called the estate of Patricia Folkes, also known as Griffin and Higgs. And this shows you, I'm bringing this to your attention really, because it shows you how things can go wrong. This was a reasonable value estate. Well, it would have been even bigger, but for the fact that some dispositions were made during the lifetime of the deceased, which some of the beneficiaries said should never have been made because they say the testatrix lacked capacity. But solicitors were involved in this case, and it's interesting because of the identity of the first two defendants and counsel for the solicitors. It was an absolutely stellar cast of top lawyers. Now that then has relevance as to costs, as we shall see. Higgs was a solicitor in Higgs & Co. Leake, who was one of the other executors, was a partner, and Mr. Homer was a chartered accountant. They were executors of the estate of Patricia Folkes, who died in 2014. They were represented by Mr. Burden of counsel. The claimant was represented by Bircham, Dyson, Bell, and they instructed Alexander Learmonth, who's now King's Counsel, London King's Counsel. Fourth defendant represented by Withers, again another London firm, instructed Talbot Rice QC, as she was then, Mills and Reeve and James Wheel of Counsel Right. It's a stellar lineup of quite expensive lawyers all involved seeking the removal of these reputable solicitors. And the case demonstrates how things could go wrong, because the hearing lasted for 5 days, 34 witness statements made by 21 different witness statements, 17 lever arch files of papers, and the matters went back some 26 years. Now, I've already told you that a court doesn't make findings. It doesn't say there was wrongdoing, and I've said that there were transactions that they cast doubt on them, whether the testatrix had capacity to make those transactions. So the court here is not going to set aside those transactions or even decide whether or not she lacked capacity. It's looking at it as a whole. Long-running, complicated dispute. John, the husband, died in 1991. Patricia died in 2014, as I've said, with wills and codicils. Alex Learmonth said that the first and primary ground, as I said, was that the executors were involved in solicitors in a number of suspect transactions. Now, that doesn't mean fraudulent. There were no allegations of fraud, but the allegations were that transactions should not have been made, and it diminished the residuary estate. Constance was one of the beneficiaries, and they said they ought to be investigated. Well, if the executors remained in post, well, they're not going to investigate themselves, are they? And they're the people with primary standing to make the investigations. She said the executors had failed to discharge their duties, and they were conflicted or biased in relation to the exercise of their discretion, and they'd billed Mrs. Fowkes for work she didn't request without client care letters or formal retainers. So this again shows how things can go wrong for an eminently reputable firm. The parties agreed the court's not required to determine the allegations, which is what I've said, or set aside the transactions, but they disagreed as to the tests. And the judge said that the appropriate test applied to each allegation is whether there appears to be, on the evidence before the court, or the evidence that could be obtained at proportionate cost, the basis for a claim which has a reasonable prospect of success, which enhances the value of the estate pursuing relative to the cost of pursuing it. What that means is, as I keep saying, and it's really important, a court is not going to decide there was misconduct or that there were inappropriate transactions. All it looks at is there a case which might have reasonable prospects of success relative to the cost of pursuing a claim, okay? The executors were removed and were replaced by an independent executor. So it shows they've lost, and the matter went back to a hearing about costs. And the costs order, because the solicitors had opposed the application for their removal until, we only speculate on this, shortly before the hearing, relatively shortly before the hearing, they thought, we might lose here. So what they then said was, well, we're going to remain neutral. Other family beneficiaries continued to oppose the application. And so what the court said was, when the solicitors and beneficiaries were opposing the claim, all of them jointly and severally had to pay the costs, but the solicitors didn't have to pay the costs after they stopped opposing the claim. So this is what I've said. The executors thought perhaps it's one of those moments, they've thought about it a bit too late, perhaps got good advice and realized the inevitable that was going to happen, which is what solicitors are often, but not always, neutral. You can oppose the application, and we'll look at cost consequences and the rules of court in a minute. So, as I say, jointly and severally liable to pay costs during the first period, not entitled to indemnity for the estate before or while they were opposing it, and a payment on account of costs was ordered in the sum of £150,000. Now, I drew your attention at the beginning to the stellar lineup of It's a red carpet of lawyers involved in that case. And I did hear, because nobody talks about the value of the cost, but it was said that the costs of that trial and all of the work was about £1 million. Now, that is not, I'm not sitting here in my Rolls Royce or Bentley. That is not the usual costs that are involved in an executor's removal case. It's nowhere near that. But it just shows you again how things can be wrong. As I've said, the appeal, the right order in respect of the second period when the executors were neutral was that the executors were entitled to be paid their costs out of the estate. Okay? So if you oppose it and you lose, you're likely to be at risk. This is one of my favorite cases, okay? If I'm acting for a claimant, if you can find it, you want to look at this. If you are dealing with this, either as a claimant or as a respondent, it's quite an important case, relatively new, and it's important because it's got some really useful quotes in it, which I will show you. It was decided by Master K, who is one of the Chancery judges sitting in London. And I'm proud of this because it was a case that was run by Heather Roberts. If you practice in the Northwest, or indeed elsewhere, she's the famous Heather Roberts. She's a contentious probate solicitor, and it was her case. So if you see, you can say Stephen Lawson was talking about you. Anyway, this is one of my favourite cases, and it's obviously one of hers because she won it. Simple and modestly valued estate, okay? So it's your classic case where everything that had gone wrong that I've been telling you about went wrong. The powers to remove an executor, the Administration of Justice Act or the Senior Courts Act, and the judge said in that case, the requirements, the same requirements apply to both. The executor said, this is the usual sort of response that you get, or typical response. The executors feel that having been appointed, there's nothing that should displace him. So he wanted to stay. He's got a will. He said, I'm executor. But the beneficiaries said, no, we want you to go. And in fact, the beneficiaries, there were two relevant beneficiaries. It was the testatrix's daughter and granddaughter, but both wanted the executors step down. It was an IHT case. There was inheritance tax payable, but otherwise it's a straightforward estate. There was nothing complex about it. And again, this is why I've been telling you. The judge criticised the solicitor because the judge said the solicitor didn't appear to have properly engaged with a unanimous request from the beneficiaries that he should consider renouncing his position. So again, it really, really stresses the importance of considering a request seriously. The judge said, I jotted a note to myself when going through some of the correspondence during the course of counsel's submissions. If all the beneficiaries, and this is the powerful bit, if all the beneficiaries in an estate want the executor renounced, it's a very powerful factor when considering the exercise of the statutory discretion. Now, again, that's why I showed you right at the beginning, one of my first slides was the Oliver Wooding quote about, oh, it's rare for a court to remove executors without misconduct. Well, this has changed things quite considerably. This is a 2020 case, and it's saying if all the beneficiaries in the estate want the executor renounced, very powerful factor when considering the statutory discretion. At no point in the correspondence does the solicitor executor appear to have properly engaged with the request to renounce. Again, hammering home everything that I've been saying to you about be reasonable, be considerate, engage with somebody who asks you to step down. That doesn't mean you do step down, but you make sure your correspondence is temperate and you give proper consideration. So the executor was removed and a summary assessment of costs, £25,000. That's much more normal figure than the £1 million rumoured costs in the Higgs case. And that's sort of a going rate. Normally costs perhaps would be a bit more than that, but that's the sort of costs that you're going to lose if an executor is removed. However, the executor didn't like that decision and applied for permission to appeal. And it went to a request Now, you're entitled, if there's you can put in a request and ask for an oral hearing. And it went to the hearing, and the judge reached the same conclusion. No, the executor was removed, and there was the order for costs. So I just want to give you a few words about costs, because there's a lot of misunderstanding about costs if you're an executor, what costs you can claim, what costs you can't claim. And I've seen it in correspondence. If executors say, you send them a letter saying, we want you to remove, they fight you, it goes all the way to trial or collapses just before trial, and they say, well, we're going to have our costs anyway, we've got £1 million sat in our bank account, we're just going to take those costs out of it. So I just want to pause a little bit now and just say about costs, because this is really, really important, because this is what it's about for your business or for your clients. This is the civil procedure rules, right? The court has a discretion, CPR 44, a discretion about whether costs are payable by one party to another. And that's not just if it goes to trial. If court proceedings are started and then one party backs down, but say the executor says, well, I'm not paying your costs, the claimant can continue with the claim. And again, I'll show you a case next where that happens, and then have an argument about costs. But court's got a discretion. The starting point is that the winner's entitled to recover costs from the loser. So that's virtually every case that I come across. If the executor's removed and they opposed rather than consented from the outset, then the winner is likely to get an order for costs against you. Aha, says the executor, I've got a second bite of the cherry, because there's another rule in the civil procedure rules, which is this one, CPR 46.3. That says that where a person is a party to proceedings of PR, the general rule, we're back on that general rule again, is that the person is entitled to be paid their costs out of the estate, insofar as those costs are not recovered from any other person. So, executor takes you to court, saying, I'm not going to stand down. Court removes you. You then make an application for costs. The claimant says, well, you've lost. And they say, okay, well, it's a fair cop, you're going to make us pay costs. But look at this rule, Judge, we're entitled to be paid our costs. However, there's what you call a practice direction supporting the rule that says that costs must be properly incurred. And whether costs were properly incurred says that did the executor obtain directions from the court. You probably know the phrase a Beddoes application. If you are stuck as an executor and some beneficiaries want you to stay and some want you to remove, you can make an application to the court called a Beddoes application that says, Judge, what you want me to do, you want me to do, right? That's what that means. But it's fairly rare that you would actually do that, because what you would say is, I'm just going to remain neutral. I'll abide by you putting an acknowledgement of service to the court. I've got the court proceedings. I'm neutral in these proceedings. I'll abide by whatever order that the court may make. Okay. So in executor removal cases, you don't generally have a Beddoes application. Did you act in the interests of the fund or the estate, or did you act unreasonably in some way? Now, the claimant's counsel is going to say, look, Judge, the mere fact that you found against them shows that they acted unreasonably and deprived them, therefore, of their indemnity. So what often happens is that if executors are removed, firstly, they lose under CPR 44, but secondly, they are then deprived of their indemnity by the court. So they end up paying the costs personally, not out of the estate, and they often end up having to pay the costs of the other parties personally, okay? And that can be huge, because just supposing there's a variety of beneficiaries, they may or may not all have the same lawyers. You can end up with the situation where you end up with paying the costs of lots of different parties. There might be 3 other parties, and the unsuccessful party ends up paying the costs of all of them. So back to Heather Roberts' case. And this is, again, if I'm pursuing somebody for the removal, we often rely on this. The first instance judge, that man, said that it seemed to him to be odd, and it seems odd to me, that a firm of solicitors is fighting so hard and incurring substantial costs in order to cling to an office that the only people who are to benefit from the estate do not want them to, right? Really powerful argument. If you've got no misconduct, you're the executors, but the beneficiaries want you to go. It was a little bit more nasty in that, because the solicitor executor started saying to the court, oh, look, how do we know these beneficiaries, they might not pay the inheritance tax that was due? That just inflamed the situation. That was pouring petrol on the fire, you know? So to start saying things like that without any evidence, now it might have been entirely different if some of the beneficiaries were charities, and charities said, oh, actually, we're a bit worried, for example, as to whether or not we'll get paid our bequests, or if one of the beneficiaries was living in a house. That's often the way that causes a dispute, and they don't want to sell it to pay us our share of the legacy. But let the charities take the strain rather than you. Let the charities or the other beneficiaries take the risk. So the application for permission to appeal was dismissed. Just two more cases to show you. This one, Fellner and Cleal, relatively recent case. A London barrister, James McKean, and Tara McInnes was the solicitor involved in that case. This was an application to remove a lay executor. They'd registered the caveat, but don't know whether you know this, you can get a grant ad collegianda bona even though a caveat is registered, okay? That's a limited grant to allows you to call in and collect the estate assets. So a caveat isn't absolute. You should, with good practice, give notice of your application, but there isn't actually a rule that says that you have to, and sometimes the probate registry don't pick it up. And so they got a grant of probate, and the executors, advised by James McKean and Tara McInnes, made an open offer to set aside the limited grant and an independent administrator be appointed. Now, that's quite a common tactic that, again, is involved. Rather than just fight, is there somebody else who could be appointed as an independent administrator to deal with the administration? They'd made a perfectly proper offer to do that. And they said, you made the application for the limited grant and we weren't on notice of the application. If you don't accept the offer, then we'll have to incur costs and we'll seek an order for costs against you. Proceedings were issued, and then the defendant agreed to be removed, but denied any liability to pay costs. Well, you've had your shot at it, really. And the fact that legal proceedings have been commenced, the inevitable happened. The defendant was ordered to pay the costs and was not entitled to an indemnity from the estate. Okay, exactly as I've been saying, this is straight down the line. This is what happens. These are, if you like, the bread and butter cases. This is what happens day in, day out. And sometimes executors will reconsider the position, but they'll do it too late. You have to work out, is the claimant really going to sue us? And if they are, do we really want to get involved with the risks of having to pay costs personally? So again, I'm stressing the importance of carefully considering requests to renounce and measuring the risk of a personal order for costs against you. Now, there's one other case I keep stressing here. These are honest solicitors going about their job, thinking they are complying with the testator's wishes, but things go disastrously wrong. You may have heard of this case involving an unfortunate solicitor called Mr. Bowser, who had a firm named after him. Again, things went disastrously wrong for him because this bloke died in 2022. You can see it's a modern case. It appointed the solicitor and his wife as executors. But the problem was, by the time of his death, they were separated, the wife and the testator. And the wife said, well, I don't think enough provision has been made for me. And she wanted to make a claim for reasonable financial provision. So Bowser said Smith is now conflicted, and more or less straight away, or very quickly, he issued what he called an urgent application to have her removed as an executrix. So he's the executor. He's saying, I should be dealing with this estate, and she's conflicted because she's made an Inheritance Act claim. So she was very clever. She agreed to be removed, but said, I want you removed. Now, if you are a defendant executor, it's a really, really difficult judgment call for you to make. As a claimant, it's a very clever tactical move to make because it's a difficult decision for the executor. What do you do? Do you step down and then you've lost your opportunity to make fees? Or do you carry on fighting? Because if it goes to a trial, you could say in part, I've won, Judge, because she's been removed. But if you've been removed as well, she's going to say, well, I've won, Judge. And a court will usually look at the overall outcome about what's happened, what were the issues. Bowser refused to step down and the matter proceeded to trial. And at trial, literally at the trial, he said, okay, it's a fair cop, I'll step down. And he was ordered to pay the costs, again personally, again not out of the estate. And even then, this is another one. He appealed the decision about costs, and it did go to a hearing. And that's the case number, the Court of Appeal hearing there. And to cut a long story short, and it is a long story because there were other factors that came out as well, including the fact that it was said that Bowser was conflicted. To cut a long story short, the appeal was dismissed. Still ordered to pay costs. So the issues here, you must, if somebody says we want you or your client to step down, you've got to consider that seriously. A defense mechanism is for you to consult with other beneficiaries. It's quite appropriate for you to do that. You're not opposing it. You could say to other beneficiaries, look, this or these beneficiaries, sorry about the typing error in beneficiaries, these beneficiaries want me to be removed. Do you want me to stay? And they might say, we do want you to stay. And if you've got a file note from the beginning that you can produce, which says, we want you to stay. This is the testator wanted you to stay, particularly if the testator's written, look, I'm worried about an application by my daughter to remove me, for example, and my daughter has indeed brought this application. It might be very powerful evidence to keep you involved. So consulting beneficiaries, if they will take the fight on for you, that's even better. Or you might get them to indemnify you. That's a bit of a dangerous one, saying, will you indemnify me in respect of my costs if I fight it for you? It can happen, but you could end up with them complaining if you lose and them being ordered to pay costs. Have you given them proper information? Have they had independent legal advice, etc.? Engage reasonably with initial correspondence. Look at the reasons why you were appointed in the first place in your file notes. And remember the personal risk as to costs. And we've shown you cases, 4 cases, where unsuccessful respondents have been removed and have been ordered to pay costs. So that, to the minute, is a thank you from me for listening to us. It's a thank you from IDR for engaging with us and joining with us in these matters and these talks. All we do is inheritance disputes. We don't do private client work at all. And a lot of people, the fact that you're here, come to us and ask us. We're happy to talk to you in the first instance, free of charge. If you've got a case, don't leave it. That's another thing we see. People come to us often and we think, oh no, you've left it too long. Why? The testator died 4 years ago, 5 years ago, and you haven't done anything. You haven't helped yourself. Come to us, talk to us. If you've got a difficult case, talk to us. There's about 20 lawyers of us here, and that's all we do. So we do it day in, day out, as I'm always saying to people. So if you've got problems and you want to, come and talk to us. So thank you for listening. Thank you for being here. Back to Lindsay.
Thank you, Stephen. That was brilliant as ever. I just wanted to let everybody know quickly, just at the end, that we have got CPD certificates available for the session. So please just direct your emails to me if you would like one of those. You may as well have one. They're free. So no brainer. I've also added the register link to the IDRN in the chat. So if you have colleagues that you feel would benefit from this session, please do get them to register to the IDRN, and they'll be able to watch it on there from later on this afternoon. We'll upload it straight away. But thanks again. Thanks everybody for coming, and we hope to see you at our next session.
Lindsay, can I just say, people have been putting in the chat some really, really lovely comments. So I do want to thank people for the very kind feedback that you've given to us. We're always open to suggestions. We always want to make things better. So if you've got comments with us or you've got other inquiries, please pass them on to Lindsay, and we're always happy to listen. But listen, on a personal basis, it's really, really kind of you to make those lovely comments. So thank you very much indeed.
Brilliant. Okay. Well, thanks, Stephen. And yeah, if any further questions, direct anything legal to Stephen, obviously. And if there's anything about the IDRN or CPD certificates or anything like that, please send across to me. But other than that, we'll see you again in October.